Thomas, this is.
Are you worried that our holding, going back to Justice Barrett's earlier question of Mr. Rosenkranz, aren't you worried that a ruling by us, as broad as you're stating it, would be a disincentive for ISP providers to provide any aid to copyright holders? Why would they bother?
I mean,
I've never heard of prosecutors ever relying on good citizenship concepts.
I agree with that, and the ISPs might not bother. I would push back a little bit against the assumption that good corporate citizenship would necessarily mean terminating repeat infringers. Imagine a case in which the individual was sued as a direct infringer, and a jury found that on multiple occasions this person had used the internet to commit direct infringement. Clearly, the court could award damages, and under the Copyright Act, the court would have authority to fashion an injunction that was reasonably designed to prevent further infringement. But could the district court enjoin the person from ever using the internet again? I don't think so. I think the general rule that equitable relief is supposed to be tailored to the wrongdoing.
I don't think you're answering my question. What is left for any inducement for ISPs to, in good faith, try to control infringement?
I would agree that not much economic incentive would be left. I'm simply questioning whether that's a bad thing. That is, if we don't think a district court could enjoin a repeat infringer from, again, using the internet.
Well, I'm not thinking you are, but I think Congress was thinking that there had to be some inducement, and that's why they provided the safe harbor.
They provided the safe harbor, but they also provided kind of the takedown notice provisions of the DMCA, and no notices like the ones that were sent here are contemplated by the DMCA. The DMCA does contemplate notices in which different kinds of internet company may be informed there are particular infringing works on your platform, and we want you to take those down. And if the internet companies do that, the result is a much more targeted approach. It's that you get rid of the infringing materials, but the rest of the platform remains intact and people can use it. The approach of terminating all access to the internet based on infringement, it seems extremely overbroad, given the centrality of the internet to modern life and given the First Amendment.
Justice Kagan?